Hi everyone, welcome to Toy Fair. Thanks for taking time out of your busy schedule to watch Is Your Brand Protected? For anyone who doesn't know, isn't sure, or just wants to learn more, you are in the right place. Let's get started and find out. Well, you made it to Toy Fair and maybe some other events this year too. You may be attending for a variety of reasons. Maybe that your brand or product will be discovered as the next big thing. Maybe you have a project you've been working on and that you've always dreamed of bringing to life, or something you just want to take to the next level. You've probably been working hard on your idea and put lots of time, effort, and money into creating something amazing. The excitement is mounting. You've been waiting for months to meet up with people at Toy Fair and hope that someone will love your idea so much that they buy or license it. The possibilities are endless. The sky's the limit. But you might be feeling a bit nervous. Have I done my homework? Am I prepared? Will someone want to pay me for my idea? Is my idea protected? What if I gave away my rights in that NDA that I signed? Can someone steal my idea? Well, unfortunately, that can happen. Case in point, someone I know came up with a children's brand that had an amazing and unique name. That person pitched the idea at a similar event years ago and got a lot of interest from a big toy company. Before signing a deal, that company wanted to make sure that the intellectual property, also known as IP, was protected and that they owned it. Before coming to the event, they hadn't taken these crucial steps and had to scramble to try and protect the IP, especially that unique name, only to find out someone who was also at that same event beat them to the punch. That person must have overheard them pitching the idea, loved the name, and protected it before anyone else could. Sorry to say the deal did not move forward. Proactive steps before the event could have prevented this from happening. Rest assured, you are not alone. Most everyone has these concerns, even if it's not their first product. And once the cat's out of the bag, it is hard to know what may happen. And if you don't take necessary steps, someone can beat you to it. But you're taking an important step by being here today and watching this session. Now it's time to try to figure out what's next for your $1 million idea. A little bit about me. My name is Pottick. I grew up in the toy industry and worked in toys on the business side for many years before becoming an attorney. I have experience with product and brand creation, licensing, manufacturing, marketing, safety, and more, all on the business side. We license brands like Sesame Street, Burger King, Pizza Hut, Wizard of Oz, and had our own branded products and even made private label products for companies like Toys R Us and Target. Add that to years of practicing law and helping creators and companies just like you figure out what IP they have, how they should protect it, and how they can make money from their IP. In my opinion, it is so important to empower yourself with the tips and skills you need to help spot legal issues before they happen. My law firm's slogan is legal advice before you need a lawyer, because I believe protecting yourself now can help make you money and better business decisions and hopefully allow you to avoid costly lawsuits in the future. Did you know that at least half of businesses will face a legal issue? And lawsuits can cost between $20,000 and hundreds of thousands of dollars, sometimes more. That alone can bankrupt your company, so it's good that you're here. My mission is to empower you with the confidence and arm you with some of the knowledge that you need to succeed. Of course, we won't have time to go over everything you need to know, but this will be a good start. Speaking of not being able to share everything you need to know, before we get started, I have to let you know that this presentation session is for informational purposes only and not intended as legal advice. And it doesn't create any kind of relationship between you and me, Stephanie Pottick, or Pottick Law, or Protect for Success. That would have to be done separately. The goal is for you to leave here today with some helpful information that gives you confidence and helps set you up for success. We all have different paths we've taken to get here today, and you can be at one of several different stages. Are you a brand owner? Did you create a unique product or invention? Maybe you're just starting out. Maybe you've been in business for a while. Maybe you already own a trademark, a copyright, or a patent, or maybe more than one. You can be a mompreneur or have an idea for a side hustle. The good news is there's always something new to learn, and any helpful tips you can pick up along the way can prevent a bad decision or disaster for your business. You never know if your idea may be the next big thing, but before you can pitch, license, or sell it, you need to protect it, or at least know what your options are. Otherwise, someone might beat you to it. Nowadays, especially with all the competition, protection can be a key to your success. I learned that the hard way before I was a lawyer and still in the toy business. Our company came up with this incredible toy line only to have our idea stolen. If only I knew then what I know now, which is one of the reasons I love to talk about this stuff. Wherever you are in the process, I'd like to help you identify key areas to 1. Identify and protect your intellectual property. 2. Make sure you own the intellectual property. And 3. Things to consider before signing an NDA. Protecting your brand and product is really all about knowing what you have and how to protect it. It's also a great idea to be able to spot issues before they become business-ending problems. First, let's identify what are the main types of IP. I'm sure you've heard of trademarks, copyrights, patents, and even trade secrets. So let's dig a little deeper here. Trademarks protect brands. They identify the source of goods and services. Trademarks include products and service names like Apple, Google, or Coke, logos like the Nike swoosh, taglines like Just Do It or mine, legal advice before you need a lawyer. Then there are non-traditional trademarks. Have you heard about those? They include sounds, think of the NBC chimes, colors, think of Tiffany blue, and wait for it, even smells. How cool is it that Hasbro protected the smell of Play-Doh? I bet you're imagining the smell from your childhood right now. I am. Anyway, great brands conjure up emotions and memories, and I can almost guarantee you that every big brand you can think of has at least one trademark registration. There are 2 types of trademark rights that you should know about: state common law rights and federal rights. When most attorneys talk about trademark protection, they're referring to federal trademarks that you can file and protect with the U.S. Patent and Trademark Office, also known as the USPTO. So if you plan to file a trademark application with the USPTO, keep in mind the trademark application process is a process. It is not a one and done. There is more to do than just file an application. To get there takes a little bit of work and know-how. First, search the mark. Is it even available? Then, choose the proper goods and services to protect. And make sure you choose the right type of application. It can typically be a use in commerce-based application or an intent to use trademark application. I'm oversimplifying the steps here, but an experienced attorney can help guide you through the process. If you make a mistake, it can delay you and end up costing you more or result in you losing the mark. If you make it successfully through the process, you'll get a trademark registration. Yay, time to celebrate, right? But wait, there's more to do and more to know about. Here's something you may not know. Did you know you have to renew your trademark after it's registered? I know some people who learned this the hard way. Someone recently told me they had a trademark registration, so I quickly looked it up for them and saw it had been canceled because it wasn't renewed on time. The person couldn't believe it. They had no idea. They said the online filing company they used never told them there was anything else to do. So just know that lots goes into filing and following up on a trademark. If you don't have time to learn or experience, don't leave it up to chance. This is where you should consider working with an experienced professional. Next, copyrights. Copyrights generally protect artistic works. They protect things like songs, think of Anti-Hero by Taylor Swift, books like the Harry Potter novels, illustrations, logos, movies, buildings, photographs. Actually, how many of you have used a photo you found online and got a cease and desist letter from the copyright owner of that photo? If you haven't, great job, but that doesn't mean it won't happen in the future. And yes, even tattoos are copyrightable. We'll talk about that in a few moments. So copyrights are another tool in your arsenal of protection. Did you know having a federal copyright registration with the U.S. Copyright Office can make you up to $150,000 per infringement? And it typically costs less than $100 for the government filing fee. Totally worth looking into. Then we have patents. They generally protect inventions or designs. Examples of patents include super soakers, Dyson vacuums, Spanx. The patent application process with the USPTO is even more involved than the trademark process. It makes sense to work with a patent attorney who can help you navigate the complicated process. Also, there's a time limit on how long after you've come up with an idea that you can protect it. So again, it's important to ask the right people, the right questions, so you can find out what to do. Otherwise, you could lose valuable rights. And finally, trade secrets. A trade secret is something that gives you an advantage over a competitor. It's basically a secret that your company has. Think of a customer list or the formula for Coke. Coke doesn't give out its formula. Instead, they use different suppliers for different ingredients and formulate the product themselves under lock and key. But in order to qualify as a trade secret, you need to comply with your particular state's laws and label materials as confidential and use contracts like non-disclosure agreements. Trade secrets are not as prevalent in the toy industry. You're more likely to deal with trademarks, copyrights, and patents. So I hope this overview information has helped you have a better idea on what the different types of IP are, so you can better identify them down the road for your brand and your business. And now that you know a little bit more, here's an interesting question. Do you own your IP? The answer is probably no. So why is that? It's probably because the default rule is, it's not probably, it is because the default rule is that the creator of a work owns the copyright to that work. So if someone else creates a logo for you, that person owns it. And you're probably thinking, wait, Stephanie, I just paid $1,000 for my amazing logo. Of course I own it. To which I'd say, unfortunately, probably you don't. So why is it important to know if you own your IP, and how can you make sure that you do own it? Think of it this way. If you don't have control over something, you won't be able to do anything with it. So if you hired someone to create characters based on a story you wrote, then unless you own the IP, that illustrator could tell you what you can and can't do with the illustrations. Yep, you heard that right. So it's important to know if you own what someone has created for you. And how do you do that? Well, you can do that by having an agreement in place with anyone who does anything creative for you. This agreement has to have special language giving you or your company all the rights. Otherwise, you could be wasting money and time on things you later find out down the road, like right after that big pitch, that you don't own and have no control over your creation. Now remember I said that tattoos are copyrightable? Did you know the tattoo on Mike Tyson's face is copyrighted? This is actually one of my favorite copyright stories. So remember the movie Hangover 2 where Ed Helms woke up with Mike Tyson's tattoo on his face? Well, that triggered a copyright lawsuit by the tattoo artist who created the tattoo. He must have been watching TV one day and saw the commercial for Hangover 2 where Ed Helms comes out of the bathtub with Mike Tyson's tattoo. He did a double take and said, wait a minute, I didn't give the movie studio permission to use that tattoo. He called his lawyer and they filed the lawsuit. The judge allowed the case to move forward and the parties wound up settling. I like to think the tattoo artist is sitting in his beach house somewhere sipping on a pina colada. Essentially, the tattoo artist created the tattoo and protected the copyright, which meant that others would have needed permission to use it. That was probably the best $85 or so he ever spent. So what's the moral of the story? Make sure you own your IP. Here's a bonus tip. If you don't own it, then make sure you have permission to use it. How would you answer the following question? Is it okay to use what you find online? I'll give you a moment to think about it. Don't read ahead on the slide. Remember I mentioned copyright infringement earlier, and that it can cost up to $150,000 per infringement, plus attorney's fees in some cases? Back to our question, the answer is no. Just because something is online does not mean it's okay to use. If you want to find out if you can use something, read the fine print. And if you can't figure it out, ask someone who can help. You should think about this when you're working on stuff like your packaging, websites, marketing materials, blogs, and social media. So the bottom line on IP ownership, make sure you know if you own the IP to the item you want to use or whether you have permission to use it. Knowing can save you a lot of heartache, aggravation, and money down the road. Know where you need to go to protect your IP. Each different form of IP has different rules and laws and guidelines for protection. Generally, if you want to file a federal trademark or a patent, you would do so through the USPTO. If you want to file a federal copyright, you would file it through the US Copyright Office. And of course, trade secrets require you set up safeguards internally and keep them secret. Here's a bonus tip. When should you protect your IP? Ideally, the time to protect your IP is before you pitch your idea or brand to a third party, you launch or present your idea to the public, or you begin crowdfunding activities. Why? Because if you don't, then someone can steal it. Timing is everything when it comes to taking steps to protect what's yours. Last, let's talk a little bit about NDAs or non-disclosure agreements. If you pitch an idea to a company, the likelihood is they're going to want you to sign an NDA, or you may request one as well. But hold on, just because it's called an NDA doesn't necessarily mean you should assume you know what it says. You should read and understand any contract, including the NDA, before you sign it. Otherwise, how do you know what you're signing? I've seen a lot of NDAs from some of the bigger toy companies, and they'll typically say something like, hey, thanks for submitting your idea, but we may already be working on something similar, and you can't sue us if we come out with a toy similar to what you're showing us. I think you get the idea. The NDA mostly protects them in those cases. And in a way, I get it. When I was in toys, we had our own R&D department, and some of the ideas submitted by outside inventors were ideas we had already thought about or were working on. A great tip is to search the companies you deal with and work with a company with a good reputation in the industry. Now, what we've covered today is only the tip of the iceberg. Knowing, understanding, and taking proactive steps are a part of any business venture. The more you can educate yourself, or at least have a basic understanding, puts you ahead of the pack. So in summary, you should identify your intellectual property, make sure you own, or at least have permission to use the intellectual property, protect your intellectual property, understand your NDA or any contract before you sign it, and of course, ask questions when you're not sure of what something really means or what to do next. There are plenty of great organizations, Toy Association, Women in Toys Licensing and Entertainment, Licensing International. These organizations are really helpful. They have people who want to help. So reach out to people in the industry. It's a great way to get help. So you should have gotten a checklist with this presentation to help you identify and protect what you have. If you haven't received it, feel free to email me and I'll email one to you. Or just get in touch. It's contact@protectforsuccess.com. I'd love to know what you think. You can get more information on protectforsuccess.com and potticklaw.com. Thank you so much for attending today. I wish you so much success and hope you stay safe and stay legal.